Welcome, everyone. I think we'll get started. I see the numbers of people coming in are slowly kind of stopping. So welcome, everyone. And my name is Ariadna Matas. I'm a policy advisor at the European Foundation, and I'll be taking you through today's event, which has been organized in collaboration with the Federation of European Publishers, the FEP, the International Federation of Reproduction Rights Organizations, IFRO, and European Visual Artists, EVA, with the help of the EUIPO as well. Before we start, let me give you a little bit of context. About 2 years ago, the Copyright Directive in the Digital Single, the Copyright in the Digital Single Market Directive gave the heritage sector new hopes to finally have a workable solution to make out-of-commerce works, including orphan works, available online. As part of this new solution, the Copyright Directive establishes a few conditions. One of them is that we'll focus, so the one that we'll focus on mostly today, is that before this new solution can be used, the material has to be published for at least 6 months in a specific portal for out-of-commerce works. This is what the directive calls publicity measures under Article 10, and it is extremely important because it gives rights holders a chance to oppose or opt out from the material being used, which is how the system is designed to ensure that there is a balance. So as you see, this portal plays a crucial role in the system designed for out-of-commerce works. And it is essential that the portal works well so that the declaration of content to the portal is easy to make and that it is not a burdensome step that hampers benefiting from the out-of-commerce works provisions, but also that the opting out works well so that rights holders can enforce their rights when they wish to do so. The European Union Intellectual Property Office was given the responsibility to create this portal. And ever since, Europeana has been working with the FEP, IFRO, and some other partners like EVA to ensure that the views of our sectors are embedded in the development of the portal. The fact that we have been doing this together is very important for us. It demonstrates that while there can be disagreement on some of the elements here and there of the articles of the directive, among these different stakeholders, this is the best solution we have at the moment, and we all want to make it work. So for us, collaboration across different stakeholders is really essential, and we would like to also encourage this type of collaboration at the national level. That is also why we're organizing this online event together, so that we can maybe showcase how some of these collaborations can take us forward. So thank you so much to the FEP, IFRO, EVA, and the EUIPO for your work. A quick disclaimer, today is not necessarily going to be about discussing the specifics of the out-of-commerce works provisions, except maybe through the first presentation that you'll hear. So we won't be discussing whether the license or the exception should apply or some other details, even though they're extremely important. But we thought today there's still a lot up in the air in many member states, so we would be mostly speculating if we went into this type of discussions. And instead today, the thing that we can celebrate is one important and tangible step, that is the launch of the EUIPO Out-of-Commerce Works portal. So before we start, just reminding you of a quick housekeeping rules. Note that this event is being recorded. To maximize your participation, it would be great if you can change your username to your first name and last name and maybe organization, so that we can kind of more or less know who's there, if you feel comfortable with that. If you want to engage with the speakers and with the rest of the audience, you can use the chat to share your thoughts and comments with each other. And for questions to the speakers, it would be great if you can use the Q&A so that we so that they're kind of more visible and we can moderate them and as the speakers pass on your questions. And finally, we encourage you to actively listen. We're very often in online events, but it can be a bit distracting sometimes to be doing work on the side. So if you can use the time that you're dedicating to this to be actively listening. And just a quick run through the program that we'll be following today. We'll have a first presentation for about 20 minutes by Krzysztof Niczynski from the European Commission at DG Connect on the out-of-commerce works provisions in the Copyright Directive. You'll have some time for questions after his presentation. This will be followed then by a presentation by Gita Verasnevichute from the EUIPO on the Out of Commerce Works portal. And you'll have some time for questions after her presentation as well. And after that, then we'll have a panel conversation among representatives of CHIs, CMOs, and rights holders to see what their take is on the evolution that this discussion is taking. So with that, then I would like to hand it over to you, Christoph, for your presentation, and thank you so much for being here.
Thank you very much, Ariadna, and thank you very much for inviting us and actually indeed for organizing this event. So my name is Krzysztof Niechczyński and I work for the European Commission for the Copyright Unit, so the unit that is in charge of the DSM directive and implementation of this important directive and different particular provisions. So again, before I start, because I wouldn't like to go into much details on different provisions, because I think many of you might know this as much as me, if not better. But I would like to highlight certain things, of course. But before I start, I thank you again for organizing this event and for all the cooperation that has taken place up until now among different stakeholders, because this is, I think, crucial for proper transposition on national level, which is obviously something that that needs to be done well for these provisions to work, but also later on for practical implementation. And this directive, as you very well know, is sometimes controversial, complex, and contains provisions that indeed create sometimes even interpretational issues, but also this kind of tensions of different actors. But I think this particular provisions might be like almost exemplary, and I hope I'm not wrong, how this cooperation between different stakeholders took place in putting this in motion and in practice, specifically on setting up the Out of Commerce Works portal. But again, today is an important day because it's the deadline for transposition. But so one chapter of this whole saga is closed, but the next one is basically open for the practical implementation. So indeed, on behalf of the Commission and behalf of my colleagues who work on this these provisions, I encourage you really strongly to continue this very good cooperation and to make sure then these provisions work in practice, because I think all of us here hope that it will be indeed the case, and there is no much disagreement, and all this rich material that is somehow hidden can surface again and can be presented to public. And as I put this in this title, we want to breathe this new life into this hidden treasures. And that is also something that I'm pretty sure authors and right holders as well wanted, that this material is not locked in and not available for the broader audience, but lives even longer than their, let's say, physical life. So this is something that we can achieve together, and hopefully that will be the case. And again, I encourage you to continue this excellent collaboration. So next slide, please. Yes, so copyright has been regarded as a barrier to basically daily activities of cultural heritage institutions for quite some time, and sharing these collections that I mentioned with the public. So that's why we proposed already in 2016, if I'm not mistaken, but I was not in the copyright unit yet, but I was involved in the cultural heritage topics. So it was proposed 5 years ago, so a long way from now until now. The directive was published in 2019, and today we have transposition deadline and the launch of the out of commerce portal. So again, quite a milestone. And a lot of these provisions that are in the DSM directive actually touches upon interests of cultural heritage institutions. And we have just briefly mentioned on this slide things that are of most interest. So text and data mining when for Article 3, cultural heritage institutions are beneficiaries. Of course, preservation of cultural heritage, exception, out of commerce works, and also collective licensing with extended effect from Article 12, which also can be of interest to cultural heritage institutions. So the DSM directive brings indeed a major step forward, and was and is considered, hopefully, I believe so, as a window of opportunity and a major indeed step forward to make this works and to use and share this with public. But as I mentioned, as with all EU directives, the provisions that we have in the directive will not or are not applying directly, but need to be implemented in the national law, and this is happening at the moment. For many member states, it still needs to be introduced into Parliament. So member states will and cultural heritage institutions will be able to take advantage of these new rules only once implemented. So success of these rules still remain to be seen. But again, if we will be able to collaborate on this practical implementation as has been done so far successfully, I believe, then we can successfully move to the next step and start digitizing and making this material available to the public. And indeed, out of all these different provisions for cultural heritage institutions, out of commerce works are the most important changes that were introduced in the DSM directive. So let me maybe talk a little bit about this provisions, but again, without going into much details, I very much prefer to listen to what you have to say and the panel discussion. So I will try to be brief. Next slide, please. Yes, so Article 8 of the DSM directive addresses an issue that cultural heritage institutions has been struggling with for a long time, so the exploitation of out-of-commerce works. So the system aims, or the directive aims, to establish a clear framework for digitization and dissemination, including across borders, of works that are out of commerce. It is also important to notice that the provisions cover works that were never intended for commercial use or have never been exploited commercially, such as posters, leaflets, or amateur audiovisual works. The directive establishes a dual regime, which consists of combination of new licensing mechanism and mandatory copyright exceptions. So the primary mechanism introduces the ability for representative collective management organization to issue license for the out-of-commerce works by cultural heritage institutions, irrespective of whether all right holders covered by such a license have mandated the CMOs. So when the CMO conducts basically a non-exclusive license for non-commercial purposes with the cultural heritage institution, this license may extend to other unrepresented right holders with a specific type of mechanism, such as extended collective licensing or presumption of representation, and that can be decided, and hopefully it is in many cases by each member state in accordance with their legal traditions. So there are two conditions that need to be met. First, CMO needs to be sufficiently representative of right holders of the relevant type of work or other subject matter, and of the rights that are subject to the license. And again, flexibility for member states, because member states can define what sufficiently representative means, but it is clear from the directive as well that CMO must first overall represent a significant number of right holders in the type of work, and secondly have a mandate from a significant number of the right holders or some rights mentioned to give the license for some rights mentioned in Article 8.1. Also important provision, the license needs to be obtained from a sufficiently representative CMO for the member states where the CHI is based. And the second condition, all right holders shall be guaranteed equal treatment in relation to terms of license. So as I mentioned, any such license can be only granted for non-commercial purposes. However, that doesn't prevent cultural heritage institutions from covering the cost of the license and the cost of digitizing and disseminating works. Licenses can also have cross-border effect, so that collections can be accessible not only from the given member states or domestic IP addresses. Next slide, please. So this is brief graphic explanation what are the problems right now and what are the objectives. I will not go into details, but we know all these things. So the clearing rights and transactional costs are very expensive and time consuming and difficult to finalize at the moment. The system supposed to make it workable, make this transactional costs much lower, and of course it should provide right holders with the possibility to obtain additional remuneration that right now doesn't take place, doesn't happen. Next slide, please. So the directive opts for a broad and elastic concept of out-of-commerce work. So according to Article 8, a work or other subject matter shall be deemed to be out of commerce when it can be presumed in good faith that the whole work or other subject matter is not available to the public through customary channels of commerce, after a reasonable effort has been made to determine whether it is available to the public. So basically, out-of-commerce works are works that are not available via any other channels, but can still, and that we all agree on that, hold great cultural, scientific, educational, and historical entertainment event value. There is virtually no limitation with regards to the type of the work. So it can be visual art, audiovisual works, written books, published, unpublished, or other subject matter protected by neighboring or related rights. So databases covered by sui generis right, broadcasts, phonograms, performances. Of course, they need to be considered out of commerce. Next slide, please. So when it comes to reasonable effort, which is kind of a crucial concept in the whole system. So the concept of good faith is a key factor for the determination of out-of-commerce status. So recital 38 gives some indication what is meant by reasonable effort. So for instance, work by work assessment should be taken only if reasonable. So it should be exception. Normally, it should not be necessary. It should not have to involve repeated action over time, but it should involve taking account of any easily accessible evidences of upcoming availability of work. in the customary channels of commerce, of course. So the idea and the rationale behind is that it should be low effort and it should not defeat or complicate the practical application of the provisions. Unlike, as you know, it happens with, for instance, diligent search for the orphan works. That's why, again, I'm stressing this importance of practical application and making these provisions work. So once CHIs have made this reasonable effort, it can be presumed in good faith that the work qualifies as out of commerce. Next slide, please. So in situations then there are no representative collective management organization that could issue license for a certain type of work, CHI can rely on the secondary mechanism. So the primary one is a licensing mechanism. The secondary one is a copyright exception that allows CHIs to make out-of-commerce works in their collection available online and take advantage of the system. But again, assuming that there is no representative collective management organization for this type of work or uses. And there are also conditions to be met. So firstly, the name of the author and other identifiable right holders is indicated, unless this turns out to be impossible. And such works should be made available or can be made available on non-commercial websites. Similarly to the licensing mechanism, the exception applies across border. And this is thanks to a legal fiction in Article 9.2 that says that the use is deemed to occur in the member states where the CHI is established. Next slide, please. Something obviously very important, authors and right holders' interests need to be safeguarded, and they are safeguarded through the requirement that a broad range of information has to be provided to authors and right holders, and through the power that directive gives them to withdraw from the out-of-commerce status without too many formalities. So in both cases, so in the licensing mechanism and exception, right holders must have the ability to opt out. So basically to prevent CHIs from making their works available. This can be done at any time, should be easily and effective, either in general or in specific cases, even including after the license itself was concluded and after the works being made available. Next slide, please. Yes, so in order to give right holders the ability to do so, cultural heritage institutions and CMOs must publish information about the out-of-commerce works in the, as directive calls this, publicly single online portal that is, as we all know very well, run by the EUIPO. That needs to be done 6 months before the works are available online or are used. This period should be or is intended to give right holders a real possibility to opt out before, again, these works are used. After the 6 months period, the works can be used, can be made available on the websites, for instance, of CHIs for non-commercial purposes again, and that happens either under the terms of the license granted or relying on the exception. So I will not go much into details because my colleague from EUIPO will discuss this quite in granular details, but we all know then the portal plays a crucial role in the whole system, and its main publicity measures of the new regime was launched today. I checked, and it's available online. So also congratulations from the Commission and from my side to EUIPO colleagues, to Gita and her colleagues, the whole team, because it was tremendous work over this period. It's not yet over, because as Gita will for sure mention, there are new releases foreseen in the future, and it's just the beginning of practical application of the portal and of the whole mechanism. So next slide, please. Yeah, so this is very important, and this is something that I mentioned at the beginning, and I will be perhaps talking about this also later in my presentations in the future, because Article 11 requires member state to consult right holders, CMOs, CHIs, other stakeholders before establishing specific requirements, and I hope that such dialogue has happened and is happening still, because for some member states the transposition period is still ongoing. And as said, I know then even without this formal member states consultation, the collaboration between different stakeholders took place and is taking place anyhow. But member states still are encouraged by the directive to further keep this dialogue between users and right holders organization, and again, I hope then this dialogue that has started will be kept and will be happening over time in the coming months and even perhaps years, to make sure then this system is useful and works in practice. So this is, I believe, my last slide. Thank you very much again for the invitation and for this important collaboration that is taking place. And this conference, this event is one of the evidences that this collaboration is effective. And thank you very much again for Europeana, to Europeana, to IFRO, FEP, EVA, and all stakeholders that has been so successfully, in my understanding, collaborating so far. Thank you very much.
Thank you so much, Christoph. Thanks so much for being here as well, and for this very good overview that helps us put the discussion into context. There's 3 questions in the chat, but we're running a little bit late. Actually, one of the 3 questions, I would rather keep it for Gita, because I think it's very specific to the portal. Another question is, what does publicity requirements exactly mean? But I think this one was probably answered later on when you had that slide about the portal. If not, I would invite the person that posted it to kind of clarify what specifically is meant by the question, and if it's not answered yet, I think you can type following up on the comment. And actually the first question, let's take a quick look at that one by Anne Bergman. She makes a reference to the comment you made about the elastic concept of out of commerce, and says whether you would agree that a CHI has to verify the books in print before considering a book as out of commerce.
So it's again, as I said, left to member states some flexibility. So I wouldn't like to jump the gun before seeing how the member states implemented this in their national legislation. And I must also admit that I don't know from practical point of view how difficult it is for CHIs to consult this database. But I would say that yes, as much as this is possible, and that's why again I'm hoping for the dialogue between CHIs and right holders to make sure that this is actually possible and it's not too cumbersome. Because again, we want to make sure absolutely that the works are out of commerce, but at the same time, it should not be, there should not be a list of requirements that would in practice prevent this mechanism from working. So let me maybe finish here, but the point is, if this is a useful channel of information to find out if the work is out of commerce or not, plus if this is not too cumbersome, then yes, I would say yes.
Okay, thank you very much for this clarification. Okay, so again, thank you for your time, Christoph. And now I'd like to introduce our next speaker, Gita Verasnevičiūtė, who is a copyright and enforcement specialist at the European Union Intellectual Property Office, the EUIPO. She is leading a number of projects at the EUIPO dedicated to copyright protection and enforcement, including the establishment of the EU Orphan Works database and the new Out of Commerce Works portal. Gita holds a master in international law and also a master in European intellectual property law and a degree in art history. So thank you so much, Gita, also for being here. The floor is yours.
Thank you very much. Good morning, everyone. First of all, before starting my presentation, on behalf of EUIPO, I would like to thank Europeana, Federation of European Publishers, the European Visual Artists, and the International Federation of Reproduction Rights Organizations for organizing this event, which is happening on the occasion of the launch of the portal. So we are really grateful for this effort. Today, indeed, we launched the portal to the public. The portal is up and running. It is available on EUIPO website, and you are all, of course, encouraged to check it. So this has been a result of 2 years of intensive work for all of us. We started work with the adoption of a copyright directive. Maybe we could go to the next slide, please. We had the pleasure actually to collaborate with all of you in building this portal. And I remember the first meeting we had 2 years ago. That meeting was organized at EUIPO, where we gathered representatives from member states, where we discussed what should be the main requirements in this portal. And then soon after that meeting, we had another meeting which was organized together with Europeana, helping us to gather main experts from different sectors, again, discussing in more details the technical features for this portal. So it has been a big joint effort from all of you. I would like to thank actually all experts who have been involved and contributed with your comments and feedback. We are really very grateful for all feedback which we received, and we also are grateful for your interest in making this system a success. Well, the portal has been established on the basis of the copyright directive, and naturally we worked also in very close collaboration with European Commission, and thanks to Krzysztof and other colleagues from European Commission who helped us to make sure that the portal indeed corresponds to the legal requirements and respects as well national implementing provisions as much as it is possible. As you know, implementation is still ongoing in a number of member states, so it has been a big challenge for us to establish the portal on the basis of this limited information which we had about national implementations. And indeed, the process was not always easy and simple. In particular, considering the time constraint that we had only 2 years for the go live. Also considering that the portal has to be as simple and easy to use as possible. Therefore, as a result, today we have a solution which is an outcome of all these different contributions and which includes key minimum features for the go live. However, I would like to ensure that this portal is not finished yet. It is open for further improvements, and we will be happy to receive your feedback after the go live as well. So we can go to next slide, please. So now looking into the portal, which is mentioned as main publicity measure in the directive, the portal itself has two main purposes. The first purpose is to provide access to information regarding the ongoing and future uses of works which are considered to be out of commerce. And here again, when we were establishing the portal, we had to consider a large variety of types of content, which has to be covered in the scope of this portal. So we are covering not only literary works, visual works, audiovisual works, phonographic works, software, video games, museum objects, but also we are covering works which are never in commerce, such as leaflets, posters, newsreels, postcards, and any other type of copyright protected content. And in order to make this possible, metadata requirements had to be agreed and harmonized to a certain extent for all these types of content. And we also had to consider main standards and identifiers for different sectors. Well, the second important purpose of this portal is making it easier for right holders to opt out from legal mechanism before and after their works are being used. And it was again quite challenging area for implementation, for practical implementation, considering that this opt-out procedure can be both general and specific. It can cover exceptional limitation or license. And nevertheless, we implemented a number of features for opt-out, which you will find available in the portal. However, what needs to be considered with regard to opt-out features is that this feature is facilitating the opt-out via the portal, but the actual opt-out decision is always taking place outside the portal. We can go now to the next slide, please. Now, when we speak about key users of the portal, we have four different main stakeholder groups in mind. Well, the biggest group will be naturally data providers. And for data providers, here we are open to collect data from cultural heritage institutions, collective management organizations, and public authorities. In case such public authorities are designated at member state level, it is left at member state decision to indicate and to legislate which organizations will be responsible for providing data to the portal. And it's not only providing data, but also keeping data accurate and consistent. So organizations which are providing data, they are responsible for the correctness of data and for managing records they provide. The second type of stakeholder for the portal, very important stakeholder, is of course right holders out of commerce works. And here we consider any potential right holder. And in order to exercise your rights, you do not need to create an account in the portal. You can access the portal as interested public user, and you can exercise your rights without creation of account in the portal. Whereas data providers, institutions, they need to create an account in the portal in order to upload records in the portal. We also have contact point authorities, which are designated already in a number of member states. And those authorities are designated in order to facilitate user registration workflow in the portal. So they will be responsible for managing incoming user registrations. And in those member states where contact point is not designated, EUIPO will be dealing with this task. It is also very important to ensure that only legitimate users get access to the portal, so that all information which is uploaded in the portal is indeed correct and accurate. Well, and of course, as the portal is public, it is available for anybody from the general public, and public internet users can access the portal and can do basic functionalities such as search, for example. We can go to the next slide, please. Well, the functionalities, concrete functionalities of the portal depend on the type of user you are. As I mentioned, in order to upload and to manage records, you need to create an account in the portal. And this is what I would like to encourage you all to do. If you are a cultural heritage institution or collective management organization, and you will be providing information to the portal either now or in the future, you can already access the portal and you can create an account. This way you will get your credentials and you will be able to access user area in the portal as a registered user. On the other hand, if you are a right holder or general public, you can access the portal, you can search for works, and you can check also general information on the portal, which provides information for right holders about rights and options available to exercise your rights. Also, quite detailed information about provisions of the directive is available on the portal as well. If you are a national contact point, you will be receiving or already received login credentials in order to access the portal as a contact point user. And please also check your email. You might receive new notifications of user requests already from today. And in those cases where there is no contact point, EUIPO will be dealing with these national contact point requests. So in principle, it is possible to start using the portal already from today. And if we could go to the next slide, please. Well, on that screen, you have main functionalities, key mandatory functionalities, which are required in order for the portal to function. So these functionalities are implemented for the go live, well, we have user registration and management, which is required. Then we have record creation function, of course, and in order to create records, you can use either user interface or you can use Excel bulk upload solution, which is quite simple solution, but of course we understand very well that it is one of the main requirements to make data automation as much easy as possible, so that you do not need to provide records manually. So we will be working after the go live on further improvements in relation to record upload in the portal, and after the go live we will be releasing advanced bulk upload solution supporting 2 standards. We will be supporting MARC standard and Dublin Core standard, and this will happen soon after the go live. Also, of course, you are able to perform modification of records and deletion of records. Functionality is available, and you can search works using basic and advanced search. As regards opt-out, there are 2 main features facilitating opt-out. One feature is dedicated to so-called general opt-out, which is available in the right holder section. By using this feature, right holder can exercise their rights either for particular member state or for several member states or even for all member states, by informing relevant organizations. However, organization details need to be entered as users in the portal in order to exercise these rights. So here I would like to give a bit of warning that it takes some time to populate a database with organization details, with user details. So in case you are exercising this general opt-out, please be aware that there might be limited number of organizations registered so far. And once this general opt-out feature is initiated, then a list with general opt-out requests will be displayed on the portal. And this list is publicly available, and it will be possible to consult this list. Another feature for opt-out is so-called a specific opt-out, which is related to particular record registered in the portal. So here, right holder is able to exercise requests for specific opt-out either for record as a whole or for particular work, for example, embedded work under a record, or for particular license or exception. And all these features are available. But again, as I mentioned, it needs to be considered that the opt-out decision has to be taken outside the portal by responsible institutions which are designated in member states. However, the final outcome of opt-out decision has to be entered in the portal again, and this will be reflected in a record status. As well, user notifications are a very important functionality of the portal. So once, for example, a specific opt-out request is initiated, relevant organization, which is the owner of the record, is getting user notification via their email, and right holder as well is being informed by email. So such type of notifications are being sent out for a number of functionalities. Any public internet user is able to see data logs which are available in the record. So by accessing the record, you can see what changes have been implemented in the record. We can go to the next slide, please. Well, very briefly, I would like to mention that the portal is supporting a number of workflows, but not handling all situations. And one of those examples would be definition of out-of-commerce work. What can be considered as out-of-commerce? So here, of course, decision has to be made outside the portal by relevant stakeholders. And once this decision is made, information about out-of-commerce entered in the portal. It is the same for reaching a licensing agreement. Of course, agreements between CMOs and CHIs have to be reached outside the portal. And once this information is available, information has to be provided in the portal, and it will be added to corresponding records. Procedure for opt-out, well, as I said already, validation of opt-out request is taking place outside the portal, but the portal is supporting this functionality. And the same is for contact point functionalities. You might need to check the details of incoming user requests outside the portal, but the actual validation of users takes place inside the portal. Now we can go to the next slide, please. And here you can see the landing page of the portal, which has been launched today. You can see the link on the top of the slide. So this is the main landing page, which is publicly available. On the front page, you can see search functionality, basic and advanced search. I'm very happy that we are going live with records, so the portal is not empty. 37 records have been provided to the portal by Hungarian National Library. And I would like to express my big thanks to the Hungarian National Library for making this information available already for the go live. So you can already search and find these records in the portal. And you can also find information about legal mechanism and about, for right holders, about your rights and options. As I mentioned, CHIs and CMOs can already apply for an account to be created in the portal, and you can further explore the portal on your own. You can go to the next slide, please. Well, here you can see the main web page where to find the portal on EUIPO website. You can find the portal in a number of places. Of course, you will find the link on our main EUIPO website, but also we created a dedicated web page to host the portal and to provide additional information about out-of-commerce works, a legal mechanism, together with the portal. So there is a special dedicated section which includes also promotional materials. Maybe we can go to the next slide. So yes, this is one of the promotional materials which has been launched also today. We have a leaflet which is available for the time being in English, but it will be translated into all languages, and you can find this information on our website. You can go to the next slide, please. And we also launched a promotional video on this occasion, and if we still have a few minutes, I would like to run this video to show it. It is a short video up to 2 minutes. So if you could see it, it would be very nice. Thank you for launching it.
European cultural heritage institutions, libraries, museums, archives hold millions of works in their collections. However, a large part of Europe's rich cultural heritage is not available online. These materials, known as out-of-commerce works, have never been or are no longer commercially available. They can be books, films, recordings, posters, leaflets, photographs, even video games. In fact, they can be any kind of creative content protected by copyright. Why is it important to have this type of material available online? Because these works are part of our cultural history, something that belongs to us all, something that can teach us something new. New European Union legislation has brought new opportunities for cultural heritage institutions to make large collections of out-of-commerce works available online. To help the exchange of information about out-of-commerce works, a public single online portal has been established by the European Union Intellectual Property Office. Firstly, the portal enables cultural heritage institutions, collective management organizations, or public authorities to record information about out-of-commerce works in the portal. As the portal is publicly accessible, you can find available information about out-of-commerce works from a variety of cultural heritage institutions in the European Union countries, all in one place. Secondly, the portal is making it easier for the right holders of works, such as authors or publishers, to exclude their works from public access if they choose to. The portal can also take care of that. Check the portal, get access to our common cultural heritage, so that forgotten stories can once again become our shared history.
Thank you very much for running this video. Well, just to conclude, EUIPO, of course, is very much interested in making this portal work and making it work as easily and smoothly as possible. It is first go live of the portal with key mandatory requirements, but we will dedicate further time in analyzing your feedback and working on further improvements of the portal, including automated data exchange solutions. As I mentioned, still this year, there will be additional release and future usability improvements will be implemented in phase 2 of this project, which is scheduled for 2022. Now, when the portal is established, I think it's very important to start populating the portal data. We already established initial contacts with a number of institutions, including institutions which participated in the testing of the portal. From now on, we are very much interested to collaborate with institutions which would be able to upload information in the portal. Technical support is available from our side. We will be supporting those who have information. Another thing where we would like to work is raising awareness about the portal, which is also very important. We will be working on further promotional materials, on training tutorials and additional content, which will facilitate spreading information about the portal and using the portal. So thank you once again for this opportunity to present the portal today and to surround these issues, to discuss these issues which are surrounding the portal. And we very much hope that the out-of-commerce system, together with the portal, will contribute to better availability of works which are currently not available. And we are looking very much to collaborate with all institutions wishing to use the portal. Thank you very much.
Thank you, Gita, for your presentation, and congratulations again on the launch of the portal. There's some questions in the Q&A. In the interest of time, I will ask two out loud, and if you're comfortable, then I would invite you to answer the others directly by typing an answer to the question. So if you open the Q&A, you will see them. So the two questions that I wanted to ask you now is two questions that are actually related. So the question is around how rights holders will be informed of the existence of this public portal. Will they need to regularly go and check whether a work they hold rights on has been registered in the database? And another very related question is, well, kind of in the same line, how will the rights holders be informed, where and by whom, that a work that they hold rights to is registered in the database on the portal, so that they can opt out if they wish?
Yes, so on right holder information, well, the portal is main publicity measure, but of course it is possible to disseminate information at national level as well, and I imagine this will be happening at national level. But of course, portal is the main contact point for right holders, and here I would encourage in the beginning right holders to check the portal periodically. But as I said, soon we will have another release, and we will have additional functionality which will facilitate information to right holders. It will be a so-called alerts functionality, which will allow right holders to subscribe to receive notifications once new information is entered in the portal. So this feature is not available now for the go live, but it will be available very soon. So it's just one of the functionalities, of course, but in principle, right holders should be checking themselves periodically, the portal.
Thank you, Gita. So I don't know if you can see the other questions in the chat. If in the meantime you would like to answer them by typing your answer. If not, we can try to get back to it in a moment.
Okay.
Thank you.
Thank you.
So now I'd like to take us to the last part of this event. Let me start by introducing you to the speakers that we will have in this panel. So we have Arlette Beking, who is the manager of collective rights at PictoRight, the copyright organization for visual artists in the Netherlands that distributes collective royalties, manages copyrights for artists, provides legal assistance, offers advice, and strives for a better copyright position for image creators. Arlette's work involves managing the collection and the distribution of collective remuneration and taking care of the interests of visual creators when negotiating on contracts for online archives. We've also got with us Martijn Zijnstra, who is a copyright lawyer and information professional from the Netherlands. He is the copyright coordinator for the Royal Association for Archivists and Archives in the Netherlands. We've got Matthias Ulma, who is a publisher and managing partner of Ulma Verlag, a publisher for professional and special interest books and magazines based in Stuttgart and Paris. Matthias is responsible, among other things, for the strategy of the publishing house, and he is also part of the French-German working group for Orphan Works, and he's also a member of the Council of the German National Library. We've also got Nina Giorga, who actually couldn't be here today, but she's got a pre-recorded video with some of her thoughts. She's a prize-winning and international best-selling author and freelance journalist since 1992, who has published 28 books, among which novels, mysteries, and nonfiction, as well as over 100 stories and more than 600 columns. In 2011, Nina established the Yes to Authors' Rights Initiative, which has been joined by 14 writers' associations and 27 publishing partners. In June 2019, Nina was elected as president of the European Writers' Council. We've got also Szabolcs Dancs, who works as a chief advisor at the National Széchenyi Library of Hungary. He is also the head of the Office for Library Standards at the Hungarian Library Institute and an external consultant for the Digital Humanities Center at the Petőfi Literary Museum. And last but not least, Walter, whose name starts with a W, so I'm sorry, but you come last in the introductions. Walter Spacemakers, who is a senior collections project leader at the iFilm Museum in Amsterdam in the Netherlands, where he manages projects in the field of digitization, digital sustainability, and the online availability of collections. So again, a quick note that this is a conversation to explore how we can go from here into working together to make a success of these out-of-commerce works provisions, because I think we all agree at the principles level, we all want to make it work. So let's focus on how to get these works connected to a public of researchers, educators, and creators without creating a prejudice against authors. And so a first question to warm up to all of you. So what essential elements do you think this out-of-commerce works portal that Gita presented should have or has in order to facilitate your work as a relevant stakeholder in this discussion? and safeguard your interests in line with the directive. I don't know who would like to go first. If not, I might just...
may I, for example?
Yeah,
so let me start with a compliment rather than complaints. I would like to say first and foremost that I would like to emphasize that this new database, this also database, what I am very pleased of, that it is partly based on very state-of-the-art approaches. I'm on behalf of literary works and libraries, and from this viewpoint, I can emphasize that it's a quite modern, quite state-of-the-art database that is very encouraging. And on the other hand, this area of managing metadata in this area, this copyright area and library area and cultural heritage area is of very high complexity. And that's why I guess that maybe some other refinements will be needed later on. As I can mention some examples which would be very required for us from our view, from our aspect. I made some notes about that. First of all, I would mention communication and data exchange between our systems as smooth as it is possible. Now there is this so-called bulk upload possibility, which is okay, which is very good, but it would be much more nice if it could be conducted through standard interfaces in a much more smooth way. And down the road, and for example, automated feedbacks from on changes in copyright status. That would be very nice. It would be some kind of data synchronization between databases. But if I want to sum it up, I would say that it's a quite good database as far as I experienced it, and maybe it's up to us. I mean, for example, museums and libraries develop such systems which would meet the requirements, because it's so sorry to talk about this such things, but I'm an expert in metadata domain, and I would say that this this so-called entity-based database, entity-based model is very encouraging and very good. And without that, we in Hungary, for example, we couldn't really identify our C works. So we should separate, we should somehow make a separation. Maybe we have to differentiate the entity, the experience, the expression, and the manifestation, the work, the intellectual content, and the book itself, because it's without that it's very hard to identify our works, and in the traditional bibliographic standards, it's not an approach that is applied, that it's not typical. So we have to develop, we have to keep up with the database, I would say. And this copyright relevancy, it isn't at these approaches we apply in this area. That, for example, let me say just a few words about that. That in Hungary we have an implementation. We adopted this law this way that we have a so-called cutoff date, which means that works last published before 21st of August 1999 could be assumed as out of commerce. It means that this, at the first sight, it might look very great. It's very simple, but it means that I would like to draw the attention to this word last published, which means that we have to check if these works have been published in the later period. So we need to cooperate both in prints and with other systems and stakeholders as well to do so. So it's quite complicated thing, but much less complicated than it was in the case of Offerworks, I think. The region search was something which was very challenging and something that was almost meets the impossibility. So sorry to talk so much about these things. Thank you.
No, that's perfect. Thank you so much. Any other thoughts on this first question?
Yes, can I add something?
Oh,
Sorry.
you can go first, Walter.
Okay.
Yes.
Okay, yeah. We tested the database, and the testing went very well. And we have 2 features that we would like to see included in a future release. First, in case of bulk upload, it's currently not possible to specify the role of the creators. And to specify the role of the creators is especially important for audiovisual collections, because these collections generally have several creators. And second, it's currently not possible to specify uncertainty in dating. And to have the possibility for this is an important feature for cultural heritage institutions, because the precise dating of a part of the collection is not possible. But these are some features that can be included in the next release, we hope. Yeah, thank you.
Thank you, Walter. Yeah, Arlette.
Yes, well, I think the portal can be a good solution for part of the archives of cultural heritage institutions, such as archives for newspapers, magazines, and books. But sorry, in order to safeguard the interests of the image makers, I would like to address the difference between the archives for images and the, for example, the archives for newspapers, magazines, or books. I think this portal will be a difficult solution for a part of the image archives. The problem is that you still have to assess every image in the archive to know whether it is still commercially available. And a lot of the older pictures are still commercially available, we see, and being sold by photographers and photo agencies. And I don't know if there exists an archive that has in copyright images, which is only out of commerce works. So I foresee a problem with image archives, and it would be good if the portal could help in some way to safeguard the interests of visual creators with regard to the in-commerce images in image archives. And I would like to point out another important element, that when a column or an image embedded in a newspaper is not out of commerce when the same column or picture is standalone. But when you look at the newspaper as a whole, you can say that an old edition of a newspaper where this column or picture is embedded in is out of commerce. But maybe this is not really the topic of the question, but I would like to. I'm wondering how to deal with this problem with the image archives, where a lot of the archive will be out of commerce, but a large part won't be. So I'm wondering how to deal with this, and when these images are being uploaded into the portal, how should we deal with this? But maybe it's a question for Gita as well.
Gita, I don't know. I don't want to put you in the spot, but if you have any thoughts, you're also, of course, very welcome to share them. But otherwise, maybe we can hold on that thought. And in the meantime, I'll ask you a second question, unless, Martin, you wanted to comment on that one as well.
Well, I wanted to say that I'm very happy that this date has arrived. I've been involved in this whole entire process for the last 5 years to see how this law developed, and it's not only these articles on out of commerce, but also the other ones that are live today in the Netherlands. As for essential elements, I am mainly interested in seeing if it will be possible to have previews in the database, because not all works have known titles and have known creators, which could be deemed as out of commerce. And then it becomes very impossible to have an untitled, unknown author in the database, and there's no way to opt out. So I was really looking forward to seeing that in the out of commerce database as well, especially given that the archives have such a wide variety of objects in their collections, with difficult heritage, difficult information about who made it, where it's from, where it was published, was it even published to begin with, and what the economic function of the object was in the past. So that's why I would really like to see previews of all the works in the out of commerce database.
Thanks, Martin. Yeah, Matthias, go ahead.
Maybe I can put another point to this, as from the point of view of a publisher. The problem is that the out of commerce works are not of a big interest for us, but the whole system only functions if we are aware of the use, if there's a visibility, and if we check the database to have the possibility to make an opt-out. But the interest for the publisher to do this, to follow the information, is very low, because the commercial value of the out-of-commerce works and the usage is not as high. There are a lot of conflicts in copyright, and of course we have to clear this. But the discussion or the complexity of the problem we are talking about is a contradiction to the commercial value. And I think this is a problem. The whole system only works if we get all the publishers aware of the situation, if we make the database visible for everyone, and if it's used. But how can I make the publisher use this database if the risk to not see a licensing of a work which is not out of commerce, the risk is so low? So it's my question: which mechanism is do you plan to make it visible, or to bring it in public, the database and the information? In Germany, we have the system of orphan works and the database together with the National Library and VGWort. And I remember the whole discussion, which was very, very long and heavy. And when it was finished, since then, I never heard anything about it. I guess it's very well working, but maybe it's not working at all. I just don't know it. And this could be the problem, that all the efforts we're doing in this database finally isn't working because authors and publishers just don't take care of it.
Thanks, Matthias. Yeah. So yeah, I think that there's, probably a duty on the side of the EUIPO, as Gita was explaining, to promote the database, but probably also on our side as professional organizations to make our colleagues aware of it. Maybe off to our next question. And here I'd like to kind of invite our Nina, who isn't present at the event. So Tamara, if you can start preparing the video that she pre-recorded. Kind of answering the question, how do you envisage the process of opting out to work, and do you foresee any challenges in this regard? So that would be a question more addressed to those of you who represent CMOs and rights holders. But first of all, let's try to play that video, because Nina created a really nice video with her ideas for us.
Dear Ariadna Matas, dear colleagues, dear speakers. My name is Nina Giorga, and I'm a writer since 1992. and I have the honor of serving as president of the European Writers' Council, the federation of 46 writers' organizations from 31 countries. Technology makes it possible to replicate myself today. I'm speaking here at the lounge of the EUIPO Out of Commerce Works portal while the EWC is holding its annual General Assembly. My thanks go out to Europeana that I may convey a recorded statement on behalf of the book authors of Europe. It is a special day in several aspects. In many member countries, the DSM Directive on Copyright comes into force, which is intended to raise equality between authors and publishers and to strengthen the economic and the moral rights to ensure the diversity of books. At the same time, the implementation of the directive opens up the way to rediscovery of the book heritage and shall enable libraries, for example, our centuries-old alleys of books and authors, to give digital access to out-of-commerce works after a certain period of time, and hopefully in agreement with the roots of this heritage, the authors. The rights to use a work revert to the author after it leaves the market. This is a mechanism that is often contractually and/or legally regulated. Therefore, the future operation of the portal needs naturally to focus on authors. It is up to them to decide individually whether and how the life cycle of their work can be extended. Accordingly, the process of opting out will face at least 3 challenges for rights owners, the authors, and for cultural heritage institutions. First, publicity, to reach the highest level of information possible. As established in the Directive on Copyright, there must be wide publicity at national level to ensure that authors are made available and aware of the institution's digitization plans and that they have access to the link to and information in the portal, and to ensure that this information is available from the start of the 6-month period of notice. Second, authors' rights and the opt-out function. There are several reasons for authors to opt out, and this must be respected. Economic reasons, for example. The author may be publishing or has recently published a revised version of her work, and the out-of-commerce version will therefore compete with a new version. A poet might compile a new collection of poems from earlier published poetry books. A crime writer moves on to self-publishing. An author may win a prize, and his or her early works may be published again. Third, the author's moral rights. Moral rights are not transferred, ever. The moral rights comprise a wide scope of reasons for authors to opt out. My personal example may show I have published 30 books in 24 years, and really not all were brilliant. I just want to put my youthful sins back in the drawer. A non-fiction author with new findings on his or her topics may also want to decide that the outdated data should not be spread. A last comment. A crucial and most essential principle is that the portal should attend to the rights of writers and translators in compliance with the directive. Keep the wording legally correct. The opt-out option must be inclusive and authors-friendly. The Directive on Copyright in the DSM uses the concept of authors, not creators. The European Writers' Council asked for this legal concept to be applied throughout in the portal, and we hope that this has been remedied. I congratulate the project leaders of this tremendous achievement of launching the portal today and wish all the readers of the future an exciting journey of discovery through the heritage of European writers' voices. Thank you very much.
Well, thanks to Nina for providing this recording with her thoughts. I think she kind of had to answer all the questions into one. So, but it's really nice to hear because you can tell the literary background in how she presents it. I don't know if the panelists have other thoughts on the opting out as a concept and in general and how it will be enforced. Maybe any thoughts on that?
Well, for us, the most important thing is that we still we have these agreements with cultural heritage institutions. Then I don't foresee a lot of problems with visual artists and creators to opt out. as long as we have these agreements with cultural heritage institutions, and also which takes care of remuneration for artists. I think that's the most important thing for us as a CMO and for the rights holders.
Thanks, Arlette. Martin, yes?
Yeah, I foresee from an information management perspective some difficulties for the archives to properly match opt-outs with works in our collection. And I hope that the EUIPO uses standards for identification of persons like ISNI or FIAF that will help the archives to identify those persons that have opt out of this possibility of the orphan works database. Oh, sorry, the out of commerce database, because that information that moves from the database to the archives, that's going to be very difficult to do.
Thanks, Martin. So I've got Walter. You wanted to comment on that one as well?
Okay. Yeah, as Film Museum, we expect the chance that the rights holder will make use of the option to opt out will be very small, because if the rights holders of a film are known, I will always contact them before a film is declared out of commerce. Because we have a very good relation with the right holders, and we always inform them about what we are going to do with their content.
Thanks, Walter. I think that's
very smart, I think.
Yeah. Just one word. Sorry, we have a cooperation with the Hungarian Book Print Company, which represents publishers, and that's the way we try to make information concerned to be available for the persons who are concerned.
These are great examples, actually. I've got two quick last questions, and the last one is slightly related to what you were sharing, which I think is kind of one of the most important takeouts for me of this conversation, I think. But before that, I wanted to quickly ask those of you involved in the cultural heritage sector if you are already envisaging to make some works available through the portal. I understand that Hungary has made some already. So if you wanted to share some thoughts on that.
Yes, we already provided some data with the bulk upload option, and it worked very well. It's very great. What so as far as I remember, I mentioned that we have an entity-based system which helps us to make these two entity levels separated, such as the expression and manifestation, that help a lot to us. And what else we need? I guess we made a mapping, but as far as I know, there is already a conversion tool somewhere in the system. What we couldn't use yet, but I hope that in the future we can provide this data without filling up this Excel table and provide pure Mark 21 or other format, other data, and it will be converted through this tool. It's also a question to GitHub, but it worked well, and it was and in a very smooth way. But we had to fill this Excel table up manually this time, but it will be much better later on, I guess.
And are you to some extent envisaging, like, kind of organizing your next digitization projects with that possibility in mind already? So kind of, are you looking at collections that you couldn't look at before, with the idea that now there's a solution for them.
Can I add something?
Yes, please, Walter.
Yes, we have, we have films that, according to the that are eligible to be declared out of commerce, and these are, for example, non-professional made films and corporate films that were produced more than, I think, about 50 years ago. But we are waiting now for. We have made a selection, and but the first step is to negotiate with the CMOs what they think about their what ideas they have about these collections, and if they think they are well or not representative for this kind of collections. Dus first we have to work out with CMOs all kinds of provisions, and the second step is then to upload a bulk amount of films as out of commerce.
Thanks, Walter. So maybe a last question to all of you, and for me, I think that's one of the most interesting ones. And some of you already kind of answered it. Are you having conversations with other relevant stakeholders in your member state to explore how to make use of the provisions, or kind of to start setting up a good relation in case you want to use the licensing provisions, etc.? If you can share a few examples, if you've got any, and maybe also use it as your closing statement, as we'll be finishing soon.
Yeah, okay.
Yes, we've had the first stakeholders dialogue, and there are 4 categories laid down in the Netherlands, and that's for standalone images, written material, audio, and audiovisual. And when I speak for Pictorite in the Netherlands, we already have an extensive practice for these types of works. We are used to enter into agreements, and we have already done it for almost 10 years now. So, but I don't know how about the categories audiovisual and audio. Maybe Walter knows more about that, or Maarten, whether it's more complicated or not. I'm not sure.
Yeah, can I say something about the audiovisual sector? Then
yes,
the audiovisual sector has planned a meeting with the relevant CMOs and to discuss the topics such as a possible cut-off date and for which audiovisual productions the CMOs are representative. Dus we have planned it, I think, in mid-June. Dus, and we hope to get a quick result. And after that, then we can go on with the process to declare works out of commerce. But first we have this dialogue with the audiovisual CMOs.
Yes, and we see ourselves as representative for the images in written material and also for the standalone images. So I don't foresee a problem in that, and I think that's important to address. And then well, I already said it, but it's the most important thing for the rights holders not to opt out is to have agreements with us about these works, out of commerce works. Yes.
And we started to cooperate with a collecting society, which is currently responsible for public lending rights in Hungary, but planning to broaden its profile in order to meet requirements of representing right holders in the out of commerce regime.
Yeah, from my point of view, I think we have a good cooperation with the collecting societies in Germany, and you should think about the cooperation that we don't have to take care of a second organization, but if the work is together, then it can come from one hand. It was very useful to make this process with the orphan works in place, and I think the cooperation can be used for the new process as well.
I think most of the things have already been said about the Netherlands. So we have, as a sector, been discussing with the archive and the CMOs together. And I look forward to continuing those discussions, especially given the diversity of the archives and all the small collections of very strange objects that we can have in our collections that might not be a regular audio material, regular image material. It's going to be interesting. And I think you hear the test siren of the Netherlands in the background. Sorry for that.
No problem. So that's great.
Too many Dutchies over here, I think.
Yeah, I
yes.
think that you're in a majority position, but it's also interesting to see how a conversation at the national level is already going forward. But thank you so much all for your participation. You've made it very easy for the moderator to walk you through the questions for a topic that can sometimes be a bit controversial. So I look forward to seeing these examples of cooperation at the national level develop. And I think this is kind of the start of a conversation on out of commerce works. I hope we can all stay in touch. So thanks again to all the speakers, Walter Arlett, Shabolt, Martin, Matthias, and then of course Gita and Christoph, and to my colleague Tamara, who is in the background clicking the buttons. Thank you so much, and we will be in touch.